Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. As usual, my name is Aaron Asiedu Entry. Today we are looking at law of contract, specifically mistake. Law of contract, specifically mistake. And before I proceed, I would implore you to like, share, subscribe, and comment. Tell a friend to tell another friend that the Law Lab is on with law of contract. The other time, together with my friend Daniel Drominta, Ms. Jacqueline Opoku, we've treated the formal or valid element of making a contract, or the element of making a valid contract, i.e., offer, acceptance, intention to create legal relation, capacity to contract, consideration. We've even looked at terms and considered privity to contract. We are now transitioning to the vitiating factors of making a formal contract. Vitiating because in as much as you have all the valid element of making a contract or the element of making a valid contract, when you see some of these vitiating factors present, it vitiates or it makes the said contract unenforceable. So when we talk of vitiating factors, what do we mean? We say that they are legally recognized factors which makes an apparent contract lose its validity when it comes to its enforcement. So you have all the valid elements of making a valid contract present, but when these vitiating factors enters in or is present in the contract, it makes the said contract unenforceable. And the point here is that it either makes the legal consequences is that it either makes the contract either void or voidable. When we say a contract is void or void ab initio, we mean that the said contract is a complete nullity. It empties the contract into stilts, in the sense that we even presume that that contract did not even exist in the first place. But when we say a contract is voidable, it means that the said contract is valid until a party to the contract takes steps to set aside the said contract due to any of the vitiating factors that is apparent in the contract. So a typical example is that I'm having a contract with my sister Jacqueline Opoku, and here is the case that, let's say, a certain gentleman, Kofi, comes to me to sell a stolen car to me, and I intend, so Kofi stole the car from Jacqueline and sold the car to me. The point here is that I bought the car in good faith. I'm a bona fide purchaser for value without notice of the said defective title the person or the said Kofi sold the car to me. The point here is that I would be having a valid title until Jacqueline make or take steps or reasonable steps to set aside the said contract. That is what we mean by a contract is voidable. Today we are looking at mistake as one of the foremost vitiating factors. When we say one is mistaken in law, it means that it is an error regarding a fact that affects the creation of a contract. It is an error regarding a fact. So to be mistaken of a fact when you are entering into a contract. But the legal effect of mistake at common law is that it makes the contract void. However, the legal effect of contract mistake under equity is that it gives you some three options. One, its mistake can be a defense in refusal of specific performance. Two, mistake can also be entitle a party to rectify a contract, and also mistake can be a ground for rescission or rescinding a contract. Right, with regards to refusal, mistake being a defense in the court granting an action for specific performance. All that we mean is that I'm having a contract with my sister Jacqueline Opoku, and the point here is that she wanted a Land Cruiser V8. She's written a Land Cruiser V8 in the contract, but she kept on pointing to a Prado. The point here is that I go to buy the Prado, and she now comes back picking the contract to tell me that I wanted a Land Cruiser V8. However, she was pointing to a Prado. So there is some sort of mistake. And so if she demands a specific performance that I should supply exactly what is in the contract, I can clearly state that there is a mistake between myself and her, because as she wrote Land Cruiser V8, she kept on pointing to a Prado. And so the court will say that because of the said mistake, it becomes a defense, and the court will not allow me to specifically produce or supply the said Land Cruiser in the contract. Now, mistake entitling parties to rectification. Clearly, she wanted a Prado, but we have written Land Cruiser V8. She pointed at a Prado. I went to buy the Prado for her. She has actually accepted the Prado, but in the contract we have Land Cruiser V8. Due to that mistake, the court can actually accept the fact that we should just rectify the said contract and put in the contract a Prado, not the Land Cruiser V8. Now the third one is on rescission. Rescission is that she wants a Land Cruiser V8. I go to buy a Prado. She can, based on the said mistake, and said that she is setting aside the said contract and there will be no contract between us. Now the point is, at what point in law would we say that a mistake is operative? Or at what point would you be able to plead that there was a mistake in a contract? There are two things you must know. For us to say mistake is operative, one, the mistake should have happened before or on the conclusion of the contract. And our case is Amalgamated Investment and Property Limited versus John Walker. What happened in this case is that the defendant or the parties were in agreement to buy a certain building, and that building was of historic importance. And the point here is that where the said building is listed by the government, it brings the value of the building considerably low. Here is the case that on the contract was concluded on the 25th of August. And as of the time it was concluded, the building was not listed. But the following day, on August 26th, the said building was listed. The said building was listed. And now the plaintiff now brings an action that there was a mistake because the building was listed and it's been sold to him at a higher price. The courts held that for a mistake to be operative, the said mistake should have existed on or before the conclusion of the contract. And in this case, clearly, the mistake did not happen before or on the conclusion of the contract. The mistake happened after, or the listing of the building happened after the conclusion of the contract. There are three types or kinds of mistake. One, we talk of mutual mistake. Two, unilateral mistake. And three, common mistake. I'll take them one after the other and briefly explain it. And in our next video, my sister Deborah Emisa will take you through all these three kinds of mistake and explain to you to the barest understanding. I believe you would appreciate her doing so. The first one is mutual mistake, and properly it is called mutual mistake or mistake as to the terms of the contract. Mistake as to the terms of the contract. It simply means that I'm contracting with Deborah. She believes that she is contracting me for an air conditioner, and I also believe that I'm contracting her for, let's say, a car. You see, the terms differ. So clearly there are no meetings or a meeting of minds. Our minds are not in addendum. And so the contract will technically be void. It cannot be enforceable. And you may look at the case of Raffles versus Mitchell House, and also the case of Falk versus Williams. When we talk of unilateral mistake, the word uni means one person, and it is a mistake as to the identity of the contracting party. So I intend to contract with Deborah. I end up contracting with Jacqueline. So I have been mistaken with the identity of Deborah with regards to that of Jacqueline. So quote unquote, and I'm not targeting my sister to be a rogue, Jacqueline may be a rogue in this particular situation. And we have cases like Phillips and Brooks, we have Ingram and Little, we have Lewy and Avery, we have Candy and Lindsay, and we will look at Kings Norton Metal versus Edridge Limited. Let's also look at the last type of mistake, that is common mistake. The last type of mistake is common mistake. The word common means that the two parties, myself and Debbie, are making the same mistake. We intended to contract for Mrs. Dona Hammond's book. Both of us believing that we are contracting for this book, we ended up contracting for Mr. Lomalije's commercial law book. Now the point is that said mistake is so common between us. It is common between us. And so in this present circumstance, the court is not in a rush to void the said contract. The court will consider other factors and actually leave it for equity to make the said contract voidable, so that where the party establishes the said mistake, the party can be able to take steps to set the said contract aside. When you enter into, or when you are looking at common mistake, there are three types of common mistake. We have one, a common mistake as to the subject matter; two, common mistake as to title; and the last one is common mistake as to the quality of the subject matter. Thank you very much for sticking through with me. Today, I started by looking at vitiating factors, and I explained what vitiating factors is. I told you that the legal consequence of a vitiating factor is that it either makes a contract void or voidable. And where it is void, we deem that the said contract did not even exist in the first place. But where it is voidable, the contract exists, it is valid until one of the parties takes steps to void or set aside the said contract. Now we proceeded to appreciate mistake as one of the vitiating factors, and we stated that for one to be mistaken, the said mistake, or for a mistake to be operative, the said mistake must exist before or on the conclusion of the contract, where we consider the case of Amalgamated Investment and Property Limited versus John Walker. We moved ahead to look at the kinds of mistake, where we look at the effect of mistake in common law and that of equity. I mentioned that in common law, mistake voids the contract, and under equity, it gives you three options. One, either can serve as a defense in an action for specific performance. Mistake can also serve or can entitle the parties to rectify the contract, that is rectification, and also can serve as a ground to rescind the said contract. We looked at the three types of mistake, where I mentioned the mutual mistake, unilateral mistake, and the last one being common mistake. Thank you very much. Kindly like, share, subscribe. This has been the Law Lab, and as I've always been saying, do not leave all your matters to God. Take some to your lawyer. Your lawyer must eat. Thank you.